All right, are both sides ready to proceed?
Yes, ma'am.
Okay, you know that you each will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes. Just let me know and I will watch the time. Also, please, I'd like to remind you that we are being recorded and we are also we are live now, and neither side should mention any victims' names or any children's, any minors' names. And if you have to refer to them, please refer to them as the minor or the child, or as if the victim, just as the victim, or by initials. Thank you very much. You may proceed.
Your Honor, forgive me. This is my first time doing this.
Okay.
I shared the link with my client. I'm not sure if he is able to appear or not.
Okay. I'm not sure either. The only one I'm seeing, I would not see, or we would not see anybody except the actual attorneys in front of us. So I really can't tell you whether he's here or not.
Sure. Okay. Thank you. Does my time start first?
Yes, please. And
Okay.
you're fine.
All right.
We don't bite. We don't even growl most of the time.
Can I ask a quick question, just for clarification? Attorney Myers, did you mean you didn't know whether your client was able to watch or whether your client could actually appear on the screen as part of the hearing?
I didn't know if he was able to appear, allowed to appear.
That's what I thought.
Yes. And no, just for your information in regard to that, no, the only ones we see actually appearing are going to be the counsel. That doesn't mean other people are not watching, you know, obviously, and may watch, but the only ones that actually appear are the counsel and the judges.
Okay, thank you. May it please the court, Your Honors. There are several issues that I have asserted in my brief in regards to this case. The first issue,
Counsel, before you begin, would you like to reserve some time for rebuttal?
yes,
Okay. How much time would you like? Up to 5 minutes.
up to 5 minutes, Your Honor.
Okay, I'll just say 5 minutes for you then, okay?
Thank you.
Thank you.
The first issue I present is that the trial court erred by overruling the defendant's motion for acquittal under Criminal Rule 25. I believe that the transcript shows that the state failed to meet all elements of the crime criminal damaging under ORC section 2909.06A2, a misdemeanor of the second degree. I have taken a look at that statute and I've broken it out into 6 different elements. The first one is to cause or create a substantial risk. Second element is physical harm. Third element is property of another. Fourth element is without the person's consent. Fifth element is recklessly. The sixth element is by fire, explosion, flood, poison, gas, radioactive material, caustic or coercive material, or other inherently dangerous agency or substance. In this case, it does not involve fire, explosion, flood, poison, gas, or these other elements specifically stated. It involves a gun. The state presented 3 witnesses in their case in chief. The first witness was the victim. Mr. Davis testified that he believed that Mr. Krowiak shot from 200 or 300 yards Mr. Krowiak was shooting from a target mound on his friend's property, and the victim alleged that that shot came onto his property and hit his barn, and bullets hit his barn. And this was approximately 200 or 300 yards away. But the victim admitted that he did not know exactly how far the barn was from the point in which Mr. Krowiak was shooting. He also testified there was a tree line between the barn and the backstop. And when I speak of the backstop, again, I'm referring to the target or mound where Mr. Krowiak was shooting. The victim also testified about the type of weapon Mr. Krowiak allegedly used and the shooting stance he was shooting from and the recoil to be expected when shooting from a standing position. However, the victim did not see Mr. Krowiak shooting. He did not examine the firearm Mr. Krowiak was alleged to have had, and he did not examine what Mr. Krowiak had in his possession at the time of the incident.
Attorney Myers?
second-
Attorney
Yes,
Myers,
Your
let me ask you a question in regard to that, because I know there are numerous issues pertaining to the testimony coming in about, the gun and the shooting and the specifics of what type of gun was used, how far it would go, all these type of things. But what I'm particularly interested in, you just said that the victim did not see the defendant shooting. And I thought the testimony was that he, in fact, when he pulled up, he was still standing there shooting when he arrived.
I believe there may be some confusion there because the victim was actually in his barn at the time the shooting had occurred, but an officer did arrive to the scene where Mr. Krowiak was shooting.
And he was still shooting when the officer arrived.
It was my understanding that the testimony presented was that Mr. Krowiak admitted to the officer that he was shooting at the target, but he did not have a gun in his possession at the time the officer arrived.
Okay. Well, we'll obviously look at the testimony and so forth. And just for your information, our bailiff did text me and say that your client is here too. So go ahead.
Thank you for the confirmation. The second witness the state presented was Deputy is it Tilako, Mr. Huber? I'm not sure. Okay, Mr. Tilako. Mr. Tilako was a responding officer. He testified that Mr. Krowiak did not have a gun on him when he arrived, that Mr. Krowiak did not admit to shooting at the victim's barn, but he did admit to shooting at the target, which the target was on the property where Mr. Krowiak was shooting at. And again, this was a friend's property, not Mr. Krowiak's property. The officer also testified that he did not know what stance Mr. Krowiak was shooting in. In terms of his investigation, the officer testified that there were no weapons or rounds recovered. There was no gunshot residue test that he conducted. He did not inspect the gun appellant Mr. Krowiak claimed to have. He did not inspect the target where Mr. Krowiak was shooting at, and he did not inspect the holes in the barn. And he admitted on cross-examination that he could not say with any reasonable scientific certainty what bullets caused what holes. The third witness presented by the state was Sergeant Priest. Sergeant Priest simply testified that he responded, he spoke with the victim, he saw the exit hole in the barn, and he was not able to identify anything. This was all the evidence the state presented, Your Honors. Basically, that there's speculation that Mr. Krowiak had a gun, he shot the gun, and that the bullets ended up in the barn just due to the fact that the barn was simply in line with the target that Mr. Krowiak was shooting at. Again, this barn and the target were hundreds of yards away. There were no photographs of holes in the barn, no gunshot residue test, no scientific evidence regarding the bullet trajectory was presented, and there was no evidence regarding the consent element of the crime charged. The second argument I have in regards to the trial court erring by overruling the defendant's Rule 29 motion is in regards to the part of the statute that refers to an inherently dangerous agency. Again, this is what we must be referring to because this case doesn't involve the other parts in the statute that talk about inherently dangerous explosives or chemicals. This leaves us with assuming that the state is referring to the gun as an inherently dangerous agency. There are no cases in Ohio that have found a firearm to be an inherently dangerous agency. The trial court, in reviewing the transcript, equated the term inherently dangerous they equated two terms. They equated the term inherently dangerous agency, in this case, with the term inherently dangerous instrumentality. Those are two separate cases. Those are two separate terms. When they equated the term, they cited State v. Lockett, which the Ohio Supreme Court held a firearm such as a handgun or sawed-off shotgun can be viewed as inherently dangerous instrumentality. Again, that's different than what the statute says. The statute says inherently dangerous agency. And I would note that both of those terms have two separate definitions. An inherently dangerous instrumentality that the trial court was referring to is an instrument or machine that by its very nature or design is calculated to do injury. An inherently dangerous agency, on the other hand, which the statute in question refers to, is not statutorily defined, but case law has held that inherently dangerous substance is one which is dangerous per se, an object which in itself has the potential for causing harm and destruction, and this is the key term, without requiring human intervention. Because the statute specifies inherently dangerous agency or substance, we can read it to mean that the legislator intended for this to be defined in line with that definition of inherently dangerous agency. Something is not inherently dangerous if it requires human intervention, such as the chemicals and the fire and the flood that the statute refers to. I would note that a gun requires human intervention. Again, I would argue that the state did not prove Mr. Krowiak used an inherently dangerous instrumentality or substance in this case. In viewing the evidence in light most favorable to the prosecution, any trier of fact could not have found the essential elements of criminal damaging proven beyond a reasonable doubt. And then I'll move on to my second assignment of error. The second assignment of error.
Attorney Myers, I just want to go back to something that you said about no court in Ohio ever referring to a firearm as a inherently dangerous agency. Are you familiar with the case of Huber v. Collins? And do you have some way to distinguish that out of the second district?
No, I did not find that case in my research, Your Honor.
Thank you.
The second assignment of error I assert is that Mr. Krowiak was denied his constitutional right to effective assistance of counsel. When defense
Attorney
counsel,
Myers, it just seems like we're interrupting you all the time, but I need to alert you that you have started your 5 minutes rebuttal. Would you like to save that 5 minutes or would you like to continue with your initial argument?
So that means I have 5 minutes left?
Altogether,
Okay.
So yes, so
Thank
you know, for rebuttal. You only have
I would-
5 minutes left even for rebuttal. So you've used 10 of your 15 minutes.
Yes, I would not reserve it then.
Okay, thank you.
The defendant was denied effective assistance of counsel by the counsel advising the defendant to withdraw his motion to suppress. There are motion to suppress issues that were important in this case. Mr. Krowiak was given information, he admitted to several things in front of the officer under interrogation without being read his Miranda rights. Counsel for defendant at trial advised him to withdraw his motion to suppress that he himself had filed. The trial court on record stated that there were valuable issues for the motion to suppress hearing. Despite this issue, counsel advised his client to withdraw the motion to suppress. That was a critical issue in terms of trial. I also believe that this conviction was against the manifest weight of the evidence and must be vacated and reversed. That's my third assignment of error. Those arguments have to do with the arguments that are similar that I asserted for the criminal Rule 29 motion. As discussed, the trial court lost its way in finding that a firearm constitutes an inherently dangerous agency. I also believe that the trial court committed reversible error when it entered judgment against appellant when the evidence was insufficient as a matter of law to sustain a conviction for criminal damaging. Again, the evidence was not legally sufficient to support a verdict because a firearm is not an inherently dangerous instrumentality. The state charged Mr. Krowiak with the wrong statute. They should have charged him with discharge of a firearm on or near a prohibited premises in violation of 2923.162. The trial court also erred by ordering restitution and entering a civil judgment against appellant when the uncontroverted testimony established that prosecuting witness had been indemnified by insurance payments. The victim's testimony himself stated that he filed an insurance claim through homeowners insurance and that it cost $3,000 to repair. The trial court, despite this testimony, ordered $500 in restitution. The fifth assignment of error is that the statute 2909.0682 is void for vagueness, as it fails to provide notice to a reasonable man of the offense involving a firearm. The statute as a whole refers to a list of poisonous chemical agents as inherently dangerous agencies or substances, then leaves us with the fact that or other inherently dangerous agency or substance. That last sentence is void for vagueness. Inherently dangerous agency or substance is not statutorily defined. Therefore, any man of common intelligence must guess as to whether a firearm is an inherently dangerous substance. The final assignment of error is that the trial court abused its discretion and erred to the substantial prejudice of defendant by allowing the responding law enforcement officers and the prosecuting witness to testify as ballistics experts without having firsthand factual knowledge, a proper foundation, or qualifications being established on the record. Evidence Rule 701 requires that any opinion offered by the lay witness be rationally based on firsthand perceptions by the witness. Here, Jason Davis offered an opinion as to the type of weapon used in the shooting stance of the shooter, but he did not examine the weapon, or see the shooter. The deputy Telco offered an opinion as to the muzzle climb, ricochet, type of rounds being used, but he did not collect shells, casings, inspect the mound, run gunshot residue test, inspect the barn, take photos, or otherwise investigate. For these above all reasons, Your Honors, I would ask that you reverse the judgment of the trial court. Thank you.
Thank you. Attorney Huber, please.
May it please the court, my name is Greg Huber. I represent the state of Ohio in this case. I tried this case to the trial court. I want to take a moment to thank each of you for taking the time to consider this appeal. This case is a matter of some importance to our office. We've been seeing more of these kinds of cases since we've been having more people move out into the townships. There are fewer gun restrictions in the township, and trying to figure out what statute to apply to these circumstances has been a little bit difficult, in the sense that there's not a lot of case law on what inherently dangerous agency means. We looked at it carefully. We considered the statute involving discharging a firearm, and we've had a problem in that many of the cases coming in involve properties that are not pertinent to the place where the firing, the weapon use is occurring. The statute referred to by Attorney Myers involving discharging a firearm requires that we prove beyond a reasonable doubt the issue of appurtenance. And if you look at the case law on the word appurtenant, it's not entirely clear. In this case, I think the entire question really comes down to how this court interprets the words inherently dangerous agency.
Counsel, I was going to say, what you're saying is not necessarily relevant to our appeal, but yet at the same rate, it seems like what you're saying is that perhaps the legislature needs to act on maybe the statutes on the books now are just not covering the concerns of the citizenry in your jurisdiction.
That may be, Judge, but from this side of the aisle, we looked at the law that is applicable to the criminal damaging statute and felt that this circumstance is covered by the words inherently dangerous agency. And so we decided to proceed with the prosecution of the case. The case referred to by Judge Sutton, the Huber versus Collins case, is out of the Franklin County Court of Appeals. It specifically does find that a firearm is an inherently dangerous agency. The Supreme Court,
in that case, it wasn't a criminal prosecution, was it?
It wasn't. It involved a negligence issue involving a civil case, but the court still was called upon to interpret the words inherently dangerous agency, and they found that the firearm does fall within the definition, and it is precedent that this court can rely upon in finding a firearm to be within the definition as applied in the criminal damaging statute. The Supreme Court in the Lockett case, the Ohio Supreme Court, in the Lockett case, which is cited in my brief, found a firearm to be an inherently dangerous instrumentality. And in looking at statutory interpretations, the courts advise that we should use common sense application of definition. The Merriam-Webster dictionary, which I cited in my brief, uses the words agency and instrumentality interchangeably. If you take the trouble to look at the dictionary definitions within the realm of common sense, a firearm would be an inherently dangerous instrumentality or an inherently dangerous agency. The case I cited from Claremont County Court of Appeals called State v. Kaysen states that the word inherently dangerous agency involves examination of the nature of the product or the substance itself. And if the product is inherently dangerous in and of itself, it constitutes an inherently dangerous agency. We would respectfully argue, and you will have to decide and tell me whether we are correct or incorrect on this, but we felt that an AR-15 weapon is an inherently dangerous agency. This court.
So counsel, let me just stop you there. So are you saying that the only reason it's an inherently dangerous agency in this particular case is because of the type of weapon that was used? So the type of weapon would determine whether or not it's an inherently dangerous agency?
No, Judge, I think definition is broader than that. If you look at the case out of Claremont County, they held that the statutory definition for an inherently dangerous agency, it's inherently dangerous if the danger of injury stems from the nature of the product. Let me say that again. The inherently dangerous question stems from the nature of the product. From this side of the aisle, any firearm is inherently dangerous. And it's a product, it stems from the product itself, and it should meet that definition. This court held in
Counsel, I'm going to interrupt you again. I think Judge Callahan is trying to ask a question.
I guess my question would be, if what you're saying is true, and I'm not saying I disagree with you, but then wouldn't that have meant that the word firearm would have been included in that statute? Or perhaps, in retrospect, should have been included in the statute? If the legislature meant firearm, wouldn't they have said so? I guess is what I'm asking.
Well, I think the definition in the criminal damage statute is simply very broad. And I think it's broad enough to encompass a firearm. Now, whether they should have or shouldn't have, I can speculate about, but I basically think there's enough precedent that a firearm should be considered an inherently dangerous agency. This court, in a case called State v. Watts in 2005, found that the criminal damaging statute was violated where a person was wielding a pipe, and found that and approved a conviction involving criminal damaging where the defendant was wielding the pipe or using the pipe and bashing the windows of cars. Made sense. I read the case before we prosecuted this case. I looked at this pretty carefully. I think the words inherently dangerous agency are quite broad. Within the definition of common accepted practice, instrumentality and agency are both used interchangeably. And this Supreme Court in the Lockett case has already found a firearm to be an inherently dangerous instrumentality. If the words are in fact used interchangeably in our vernacular, and they are, and that can be seen in the dictionary, I would argue that the criminal damaging statute is broad enough to encompass the factual scenario as to what occurred in this case. I think that's what this appeal really comes down to. This court will have to tell us whether we're correct or incorrect in terms of how you view it. I knew that going into the case. Nonetheless, I thought what happened here was not good. In terms of the weight and sufficiency, I thought the facts were good facts for the state of Ohio. The victim, Mr. Davis, was in the barn when his barn was hit by bullets. He was able to describe the impact of the bullets hitting the OSB, flying off when it happened. The discharge of the AR-15 weapon was going on prior to him entering the barn, so he heard the noise. He testified to that. To answer the question raised by Judge Carr, he went to the place where this was occurring, and at page 28, 29, 30, you'll see in the transcript that Mr. Davis saw Mr. Krowiak firing the AR-15 in the direction of his barn when this happened. So in terms of time and occurrence, the facts are plenty sufficient to support a conviction in terms of establishing that this gentleman was firing a weapon that will discharge bullets that travel 800-900 yards directly in the direction of his barn. The victim was there when it happened. He testified. The victim's a Marine for 4 years and knows what happened with an AR-15 is discharged from an upright position. It's easy for the muzzle of a gun like that to raise, miss the backstop, and bullets enter his barn. He also testified that this kind of thing had happened prior to June 28, 2020, when this case occurred. He confronted Mr. Stout about the problem. They did not do anything to remedy it. And at the end of the day, he ended up being the victim of bullets entering his barn, which cost him, while he was lucky he wasn't hurt, he's lucky his son wasn't hurt, who was in the barn. He did have to expend money to fix his barn. So from our side of the aisle, we would ask the court to look at the dictionary definitions of instrumentality and agency. Those words are used interchangeably, not only in the Merriam-Webster dictionary. If you look at the Amjur jurisprudence section I cited, the writers in the Amjur treatise use instrumentality and agency without applying different definitions. They use them as the same word. We would respectfully contend that the intention of the legislature was to have a broad definition to cover criminal damaging. And we need this statute to cover this situation where we don't have properties that are appurtenant, but we have criminal damaging occurring because of what somebody's doing with an inherently dangerous agency. And so for those reasons, we would ask the court to support the trial court's finding of guilty. We think this did constitute a criminal damaging violation, but at the end of the day, I knew that this court might look at it. Frankly, we'll follow what you advise us. Appreciate you taking the trouble to look at these, examine these statutory words and give us your understanding as to what they mean. We tried to do the best we could with what we had at hand, and I thank you.
Thank you. We appreciate that. And Attorney Myers, you do have about 3 minutes remaining.
Thank you, Your Honor. I would just go back to the fact that the state keeps referring to inherently dangerous agency and inherently dangerous instrumentality as coextensive, as the same type of definition, as the same type of terms. But I would note that the two definitions are not exact, and that inherently dangerous agency refers to in substance or an agency that doesn't require human intervention, while an inherently dangerous instrumentality states merely that it's an instrument or machine that by its very nature is designed to do injury. So both definitions refer to something that's designed to calculate injury or harm, but only the inherently dangerous agency states that it requires human intervention. Again, a gun requires someone to pull a trigger to pick it up. These other things that the statute specifically refers to, such as explosion, flood, poison gas, radioactive material, are things that can happen on their own without any human intervention. So I would have the court note that. Thank you.
Thank you both for your presentations to the court. We appreciate your arguments. We will take the matter under advisement and issue an opinion that will be sent to both parties, as well as it will be released on our website and the Supreme Court website. So thank you very much, and the court will be adjourned.